All right, so if a guy on a dirt bike runs from you and you find him 15 minutes later sitting on his stoop, on his curtilage, can you just go up there and arrest him? My name is Anthony Bandiero, attorney and senior legal instructor for Legal Law Enforcement Training, bringing you another Roadside Chat. This officer is from Rhode Island. He says, all right, so I tried to conduct a traffic stop on a dirt bike. The dirt bike took off at a high rate of speed. I was able to identify the suspect through various methods. Number one is there was a witness who saw the guy take off from me, and he actually knew the rider of the motorcycle. He says, hey, that guy lives at the house over there. All right. Also, I think he showed this guy a picture of the suspect. He's like, yeah, that's him. That's the guy that lives at that house over there. The next thing is that the officer also saw the guy's face. The motorcycle rider looked him up in the DMV records because the guy had a plate. And yep, that's the guy. So he finds the house. He goes to the house about 15 minutes later, and he sees the guy, sitting on his porch. Could he have gone up there and just snagged him off of his porch? And the answer is going to be no, because we have a few rules we got to cover. Number one is Lange versus California. That tells us that hot pursuit in and of itself does not automatically allow us to enter a person's home or its curtilage, because that's the equivalent of a home. In order to make a warrantless arrest, we have to have some form of urgency. I'm not seeing it here, but I could be wrong. What can't wait, right? The guy he's not armed and dangerous. He's not going to be able to destroy evidence. If you're going to articulate, he can hop on the bike and take off again. I guess you can go down that road if you want. Excuse the pun. But, I mean, really, you already know who he is. I wouldn't play that game personally. We also know that Payton versus New York, a case from 1980, says that the severity of the crime does not in itself allow entry into a home. We also know curtilage is treated like the home, so apply the same rules. So even if this guy committed a technical felony, like in many states this would be, like in Texas and so forth, to be a felony alone is not going to get you into the person's house. So the problem here is that, when you step onto this person's curtilage and you're going to just, wrap him up in handcuffs, and then you're going to go to court and you're going to say, the court says, just so we're all clear, what gave you the authority to arrest this man on his porch? And what are you going to say? Right? You can't say consent because you didn't have his consent. You can't say warrant because you had no arrest warrant. And you can't say a recognized exception based on the facts that we have here. You can't call this plain view because plain view does not address when evidence or a person, I guess, is on their curtilage. You can look at Collins v. Virginia for that. That's where the stolen vehicle was in the guy's carport, and the cops took it, and the Supreme Court said that wouldn't work. So plain view wouldn't work. PC alone wouldn't work. That's our Payton case and our Lange case. So what are you going to call it? You would need some agency. And again, if you have it, then articulate it. I'm not telling you what to do. I just personally don't see it, but maybe you do have it. So now one little twist of the script here, I think it will work, but you have to think about this, is that what about a knock and talk, right? The guy just ran 15 minutes ago. How about, based on what we see here, just go up to him and talk to him and ask him, hey, what's going on? Why'd you flee from me? You don't have a license? Is that what it is? And that's not, and whatever. Nothing in this fact pattern says that you cannot do a knock and talk. The other thing is, there is no case out there that says that once you are lawfully present, right, knock and talk, or whatever, or an agency and you're conducting an investigation, that at that point, that because you would have lawful access to the person, that you couldn't just arrest them right then and there. So I guess my point is it's different. The cases seem to be pretty clear that just going up to the guy's curtilage and putting him in handcuffs and taking him with you is prohibited. But also other cases have held that as long as you're lawfully present, if you still have PC after talking to him, you can say, okay, well, look, since I'm here, I have lawful access to you. You are now under arrest. You see the difference there? It's a difference that actually is significant, right? It's legally significant. So just think about that, but that answers the question. I hope you guys like what we're doing here. Like, subscribe, share with your friends. And one more thing is we have a ton of free webinars every single Wednesday. Did you guys know that? Did you know that we do, Blue to Gold does a free webinar about an hour long, plus we have a show at the end, a call-in show where we answer questions live. Do you guys know that we do that pretty much every Wednesday? Go to bluetogold.com and check out the upcoming schedule. We're scheduled out to almost the end of the year. Okay, so check it out. Until next time, my friends, you stay safe.